Well, good morning, everybody. It's great to be here. As you can tell, we're some 9 months into this remote working and learning and teaching and presenting, and we still haven't worked out all the kinks. So I apologize for the last-minute delay in getting this all set up on our end. But it's great to have everybody here. Welcome to the annual 2020 Sherman and Howard OSHA update. It's great that we can do this presentation, although if I had my druthers, it would be in person and shaking some hands and having some breakfast with some folks like we normally do. And knock on wood, we'll be doing that again next year. So many thanks to our staff, Alyssa McLaughlin, for helping us set this up. We have a good presentation for you today. We're going to be discussing some COVID topics, talk about what we can expect under the Biden administration when it comes to OSHA, and be able to field some questions as well. So feel free to shoot us your questions on the Q&A section at the bottom, and we'll be able to kind of digest those as we go along and answer them at the end. So I'd like to turn it over very briefly to Trish Ennis from the Colorado Safety Association, who has been a great partner of Sherman and Howard's for a number of years to speak on a couple of issues very quickly. Trish, thank you.
Thank you, Pat. Colorado Safety Association appreciates, and I appreciate the support we get from Sherman and Howard. You may know Pat is on our board of directors and has been a great partner for us, and we appreciate our opportunity to join in on this event every year. We've been helping Colorado stay safe since 1968, so a number of years, 52 years we've been around. You know, this year has been a pivot for us, as it has for everyone. So all of our events are now available as virtual sessions. We still do a little bit of in-person training, but the majority of our classes are on Zoom now. Having said that, we also do virtual consulting services, and so we're working with lots of different organizations to help them stay on track this year. We are having our annual membership meeting on Friday, and we've named it a BYOB meeting this year, so it's a bring your own breakfast. Unfortunately, we're not going to be at the Denver Botanic Gardens like we have in the past, but we're looking forward to our membership meeting on Friday. For those of you who are members, we hope you will join us for that. We'll be voting in some new board members coming up. So we're looking forward to that, and I'll be doing a workshop on creativity as well, just as a kind of a thank you to our members for joining us for that. Some of our things coming up as well is we're doing a session on eye wellness, and we've got some home office ergonomics information that we'll also be sharing with people to kick off the new year. So thank you, Pat, and thank you, Sherman and Howard, and thanks to everyone who's attending, and enjoy the presentation today.
Thank you, Trish. We appreciate it. We'll go ahead and turn it over to my partner, Dana Svendsen, who will provide us some updates on what's going on out there with OSHA and COVID-19. Dana?
Yeah, well, I just wanted to kind of give a high-level view of what's going on with OSHA and COVID-19. I thought I'd go through some data that we're seeing as far as complaints and inspections, and what OSHA has really shared with the regulated community as far as how to best, get through this COVID-19 time, and hopefully get through it by keeping your employees safe, and also without any enforcement. So just a review of what we have here. Basically, the data I was able to pull was from December 2nd, but federal OSHA, as of that point, had received over 11,000 complaints in relation to COVID-19. So, and then additional almost 1,500 referrals from other agencies. As of this point, OSHA considers almost 85% of these closed, but 15% still remain open. They're still being investigated or are looked into. As a comparison, Colorado is a federal OSHA state, and we're kind of lumped in with all the rest of them. But state plan states have had, let's see here, over 35,000 complaints in relation to COVID-19. I would guess a lot of those that have been tallied up would be from California. And we've seen, and Pat's going to get a little bit more into this, but some of the states have really gone off on their own and decided to do their own thing in relation to COVID. We just recently put out a news alert, or we're going to very soon, about the Cal OSHA new emergency regulations, which are quite onerous. But one thing to consider with those is perhaps with a new administration, they may decide to try something more aggressive like that as well. So I'll let Pat talk more about that, but just kind of a comparison there. There's been about 12,000 complaints federally. Several more have occurred in state plan states. So let's narrow this down a bit. Where are we? We're in Region 8. That would include Colorado, and then we'd be lumped in with North Dakota, South Dakota, Montana, Wyoming, and Utah. And of those 12,500 some complaints that federal OSHA has received, only 578 of them have occurred in Region 8, and probably even less. Obviously, all those did not occur in Colorado. This represents less than 5% of the complaints to federal OSHA nationwide. It's just, this is not where the federal OSHA activity is happening in regards to COVID. I know Pat and I have filled a few queries, but mostly they have been responding to complaints, and it has not been in the thousands by any means. If you look at the data, a lot of the federal activity is occurring in the east, in New Jersey and in New York is really where you see most of it. But just to kind of give you perspective, about 5% of it's even happening in our region. Next slide, please. So, how would we break these complaints out? You can look at them and you can see that they really are the highest amount of them are occurring in healthcare. And then after that, you get your retail trade, which is the general, and then you can break that out more into grocery stores, and then construction and warehousing, restaurants. I mean, this is where we would expect to see the complaints. This would be the people that are so front-facing in the community, the essential workers. So this is more of a breakout here. So what has OSHA done with those complaints? Well, they have formally opened 1,200 and some inspections related to COVID. So, and again, those are largely focused in New York and New Jersey and on the East Coast, but looking at them at a high-level view, 720 of those opened inspections are in relation to a fatality or a catastrophe. So the fatality would be probably reported COVID death, or if there's more than one at a workplace, certainly they are going to show up and open an inspection. Only 273 were in relation to complaints. So taking all those, the 12,000 complaints and distilling them down, 273 of them were actually in relation to those types of complaints we received, and then only 200 in relation to the referral. So certainly, every complaint that OSHA received is not being investigated. A lot of them are, employers are receiving those rapid response letters that they need to comply with until OSHA, basically respond to the complaint in a written manner, and often that will just close the complaint. But some of, certain complaints are being investigated. On the other hand, the state plans, who've had the 35,000 some complaints, have opened almost 4,000 inspections related to COVID-19. So in certain states, this activity is heightened. And to do the comparison, next slide, to what's happening in Region 8 again, you can see that we have only had 21 COVID-related inspections opened by federal OSHA in Colorado, including North Dakota, South Dakota, Montana, Wyoming, and Utah. So they haven't even broken them down as far as how many would have been opened in Colorado only. But I can tell you, even just the Region 8 activity, it only represents less than 2% of the COVID-19 inspections performed by federal OSHA nationwide. Why is this happening? I'm not sure. it is interesting to kind of look at that and see how much we are not representing the OSHA activity. I mean, perhaps, in Colorado, our state was early to adopt stay-at-home orders and mask mandates and requirements for workplaces. Perhaps in that way, OSHA felt encouraged by what our state was telling the workforce to do, whereas in certain other states, maybe that didn't occur. But for whatever reason, we are not the COVID-19 inspection hotspot or complaint hotspot nationwide. Next slide, please. So, what is OSHA citing in these inspections? They have provided a guidance document to the regulated community, and it's the types of citations you would see in medical facilities, and that would certainly bear out when you look at the actual citations that have been issued so far. One of the most frequently cited standards in a COVID inspection is a failure to provide a medical evaluation before a worker is fit tested. They're also issuing citations for failure to even perform an appropriate fit test for those workers that use those tight-fitting respirators. And of course, when I'm talking about respirator, I am not talking about your run-of-the-mill mask that we would be wearing, to comply with the state order. This is the respirators that are required under the OSHA regulations already for people that are exposed to certain types of pathogens or hazards. Other types of OSHA citations that they're issuing would include workplace assessments, and I think that this one would probably be a common one if your workplace was visited by OSHA in response to a COVID death or a COVID complaint. One of the first things the OSHA inspector is likely to ask you is how you have assessed the workplace to determine if COVID-19 hazards are present or likely to be present. And basically your PPE evaluation, and that's something that you have to do in every workplace, but now there's just a new hazard to address as part of the process. OSHA is also expecting employers to establish, implement, and update a written respiratory protection plan if their assessment determines that respirators are needed to address hazards in the workplace. Again, I think that this is showing up frequently because of the medical facilities that are being inspected and where the complaints are occurring. Additional frequently cited standards we're seeing is the need to provide an appropriate respirator. So perhaps the respirators that's being provided by the employer is not correct to address hazards. And then also the training on use of safe use of respirators and other PPE in the workplace. Perhaps these workplaces in response to COVID, if they figured that they needed respirators, perhaps they handed them out too quickly without providing proper training. There's another part of the training might be how to properly care for the respirators, to store them, and to keep them protected from damage, contamination, and deformation. So just kind of anything to do with respirators is certainly on OSHA's radar in relation to COVID-19. Next slide, please. If you are not a workplace that would need to be concerned about having respirators for your employees, these are the ones that you would likely see in response to a COVID-19 related investigation. That would be a citation for failure to report a fatality within 8 hours of finding out about it. So if you have a worker, and Pat's going to talk more about reportability in a few slides here, but if you have a worker that catches COVID and you determine it's work-related, if they end up dying from COVID within 30 days of catching it, you need to report that fatality to OSHA within 8 hours of finding out about it. So that is, I think that's what's really driving a lot of these COVID-19 related inspections. So hopefully you are keeping yourself and your workers safe, and that is not even a possibility or happening at your work site, but if that was to happen, that is what OSHA is requiring. And then because OSHA is now going into the workplace to look at COVID-19 issues, they are, of course, looking at the records of work-related fatalities, injuries, and illnesses. And this is something they do on every inspection. If you do not have these records, if they are not filled out properly, you will likely to receive an enforcement action. Next slide, please. Pat, I'm going to turn it over to you.
So I'm gonna pick up on where Dana left off there on some record keeping issues. This is one where OSHA has been all over the board since March when the COVID pandemic hit. Initially they said only certain industries have to log COVID related instances, and that would be medical providers, first responders, industries like that. And they basically gave everybody else a free pass. So that changed a few months later, where they basically said, okay, everyone has enough of a handle on this, where every industry should be recording these instances of COVID-19 in the workplace. But we being OSHA, recognize that it's going to be difficult to make the work-related determination. So, and that's, I think, of all the COVID questions I get, this one is probably the most common, is I now know that my employee or multiple employees are positive for COVID-19. Do I have to record that on my 300 log? Well, these are some examples of what OSHA itself is suggesting that you do as part of your investigation. And my favorite is number one: ask the employee where he or she got COVID-19. Well, that's not going to be real useful in most cases, especially if the answer is, well, gee, I probably got it here. So that's not going to be enough for you to make that determination. Now, on the flip side of that, it's also probably not going to be enough if they say, well, gee, I don't know, maybe I got it at home or at a barbecue last weekend, when you have other evidence to indicate that it might have been transmitted there at the workplace. So number one, whichever way the answer goes, does not end the analysis. You have to actually dig into a little bit more of what their off-duty non-work activities are, without violating privacy or other kind of protected areas. You don't want to ask somebody, have you been attending church services where more than so-and-so number of people are present, or anything like that. You just basically say, have you been to any gatherings outside of work where there were large crowds that weren't maintaining social distancing or wearing masks, without really getting into direct questions as to what those are. So that gives you a little more information, but really it's the third one that's probably the most important. What is their work environment? Are they on a line with other people who may have transmitted the disease? Do they work kind of in isolation? That sort of thing. I got to tell you, in all the calls I've gotten on, do I record a COVID instance, there's only been a handful where I've said, yeah, I really think you need to. And one example was two workers who were working together in a remote location. One had it and the other one got it. So the first one, we don't really know where that person got it from, but the second one was only around one other person, and that was the other worker. So I said, no on the first and yes on the second. So this is some of the information that again, OSHA will look at in issuing a citation for failure to record. Is there that cluster? Are there several cases that are more likely than not? And that's the standard. Keep in mind, is it more likely than not that this person got COVID-19 at the workplace? It doesn't have to be proven definitively, but when taking all these considerations into account, is it more likely than not? Number two, this is another thing they'll look at. Customers or coworkers, was there close contact there? And this gets into a lot of contact tracing that employers really should be doing anyway. Do you have that information through contact tracing that, yes, this customer that came in has notified us that he or she since has tested positive for COVID-19. That person was in close contact with one of my workers who now has COVID-19. That's going to be evidence that OSHA is going to look at in determining whether or not it's work related. And number three is just a community transmission. And we've seen this in certain areas where if it's just kind of spreading like a wildfire, OSHA may, especially within a workplace, OSHA may consider that to be evidence of work relatedness. Now that's going to cut both ways though, because obviously your workers maybe in a facility where it's spreading, but they're also out in the community where it's spreading. So can you as an employer say that it's more likely than not that happened in the workplace? And again, it's a case-by-case analysis, but I think more often than not, it's going to be hard to record these on your logs. Okay, there's one, so evidence that OSHA might consider against work-relatedness. If your job duties don't include that regular and frequent contact with the general public or with other people, just the opposite of what I've discussed in the last slide. And then to the same point, if you work in more isolation, but you live in a community that either has a spread or there's frequent association with people that are infected, then again, that's going to militate in favor of you not recording it. So that's everything I've talked about up to now deals with work-relatedness considerations. What you also need to consider, and this is for recording. Another thing you need to keep in mind is, do I report to OSHA? As Dana mentioned, you have to report any fatality that takes place within 30 days of a workplace exposure, and you have to report any hospitalization that takes place within 24 hours of an exposure. Now here, OSHA has been more back and forth than with any other issue. At first, again, they said most industries aren't even covered, and then yes, all industries are covered. And then they had this guidance out for a while that really read like any COVID case you have, hospitalization or fatality, has to be reported to the agency without a determination of work-relatedness. Now, they since backed off of that, and of course that was never enforceable because the regulation says it very clear that the fatality or the hospitalization has to be work-related. So they're back on that now. So you really have to make that work-relatedness determination. But in addition to that, you have to determine when the person contracted the illness at your work site to determine whether or not it's reportable to OSHA. In many cases, somebody will get sick, they'll go home, and then they don't enter the hospital for 2 or 3 days afterwards. Well, guess what? If they've been out of your workplace for more than 24 hours before they go to the hospital, that's never reportable to OSHA because it's physically impossible that they got that infection within 24 hours of the hospitalization. So look at those really, really carefully. You don't want to pick up the phone and call OSHA and report these unless you have to. And I think, unfortunately, what about the case where the person falls ill one day, does enter the hospital on the same day? How are you to possibly know when the person, if they got sick at work, when that took place? Now, in a case like that, you may want to err on the side of caution and call OSHA, but really look at those cases carefully because a reported hospitalization or fatality are really gonna get into get OSHA into your facility. So take a look at these very, very carefully. Don't over-report. Make sure that you're looking at them under these types of questions. So, and I'll turn it back over to Dana for some CDC guidance.
All right. Well, I just thought I'd bring everyone's attention to this. It's been out for a few weeks now, but the CDC has said that if you have someone who's asymptomatic, their quarantine can end after day 10 if no symptoms have been reported. And then also if there's testing available, quarantine can end after day 7 if you have a negative test at that point and no symptoms are reported. But along with that, they would expect anyone who's doing that to continue to symptom monitor and wear a mask through day 14. This, information is helpful to essential workers or people who have several workers who have tested positive for COVID but are not showing symptoms. But I can tell you that on a call with industry groups last week, a CDPHE representative indicated their chief of staff said that they had not decided whether they were going to deviate from their current recommendation for a 14-day quarantine period. So as of right now in the state of Colorado, the CDPHE is still recommending a 14-day quarantine period for anyone who tests positive for COVID-19, even if they're asymptomatic. But if you want more information on this, you can certainly go to the website that's on this slide. So, what is happening with OSHA and the COVID-19 enforcement trends? We've kind of talked about, what we're seeing out there, but, you can see it. OSHA has tallied it up. They have issued, as of last week, they had issued 255 citations to various entities. That would be almost all of those were healthcare facilities. And the largest penalty was $32,000. This is certainly not anything, it's just not, I don't think it's a large part of what OSHA is actually doing right now, but it is out there, and I know it's on top of mind. So that's what we've seen nationwide, 255 citations, again, largely occurring in New York and New Jersey. That would be account for a lot of them, and almost all of them are healthcare facilities, and if you look at the names of them, they appear to be homes for extended care and stuff like that. So let's go to the next slide, please. Oh, I did have some information. It's also in Colorado, there's only been one citation issued. So that can just kind of put it all in perspective for you as far as, what is actually happening here in the state of Colorado. But I'm going to move on to the Public Health Emergencies Whistleblower Law. If any of you were able to join us this summer when we had the Labor and Employment Seminar, you heard us talk quite a bit more about this. This law, which was voted on this last spring, prohibits a principal, which is an employer, but also anyone who hires independent contractors, from discriminating or taking adverse action against workers who raise concerns about workplace health and safety practices related to a public health emergency. So what they're talking about here is COVID. If somebody complains about workplace health and safety practices related to COVID, they are protected from having any discrimination, retaliation, or adverse action in relation to that. So, and then also it's prohibited to discriminate against anyone who voluntarily wears their own personal protective equipment. This would be someone who decides to wear an N95 respirator, even though the workplace hazard assessment would not necessarily require that. That was what was kept in mind here when they implemented this provision of the law. Also, gloves or face guards. Employees can wear the ones of their choosing as long as there's not another hazard that's presented by that. So what happened with this law? It was implemented by regulation, and there are some rules, and they are called the Colorado Warning Rules, the Whistleblower Anti-Retaliation, Non-Interference, and Notice-Giving Rules. They can be found at 7 CCR 1103-11, and they were adopted November 9th and effective as of January 1. This is a very fast rulemaking period, so here we are. We have a lot of rules that we've had recently enacted. So we're just really kind of trying to deal with them as best as we can. And this Colorado Warning Rule is larger than just the Public Health Emergency Whistleblower Law. It adopts several and implements the legislative enactments and rules for retaliation, interference, for the public health emergency, and then for other types of rights, and also requires that workers receive various forms of notification. The two laws that finally it mostly deals with are the Healthy Families and Workplaces Act and the Public Health Emergency Whistleblower Law that we just discussed. So the warning rules talk about how you would make a complaint to the state about the retaliation you're receiving. In addition to that, a large section of the rules talk about the notice and posting rights, requirements for rights and responsibilities. So under the warning rules now, businesses are required to have a poster informing all employees and workers of their rights under the HFWA and the THEW laws. This poster must be displayed as required by the regs, and the statutes. In addition to the poster, you also need to provide a written notice of the Healthy Families and Workplaces Act to each employee. And the posters and notices required by the rules need to be English, and also any language that is the first language spoken by at least 5% of the workforce. So that could include Spanish and possibly other languages that are spoken at your workplace, so please do keep that in mind. This poster for 2021 has been published to the public. This is the website where you can find the poster. And again, next slide, please. This is what it looks like. You can see it has a lot of information on it. And basically it tells workers about their paid leave rights and their rights to express workplace health concerns and use protective equipment. It tells them how to make complaints and what these laws provide for them as far as paid leave. I would say that the Warning Act is focused 80-90% on paid leave rights and much less on the public health emergency whistleblower law, because a public health emergency would be required for that provision to be in effect. While we're having one now with COVID-19, that may not always be the case. So look into this, certainly be aware of it, and make sure that this poster gets posted in your workplace so that you are in compliance with the law. Okay.
Well, I don't know if anybody has heard, but we had an election recently that is going to have significant ramifications for OSHA. So I'm going to spend a few minutes talking about what to expect from OSHA under the Biden administration. And I recall doing this 4 years ago, and roughly 30 to 40% of my prognostications turned out to be accurate. So take this for what it's worth. We don't know a lot yet, but here are some folks whose names have been thrown out as Secretary of Labor. A position that's obviously a cabinet level position, requires Senate confirmation, and the Labor Department obviously oversees more than OSHA, the NLRB and other areas. So some of these are familiar names. There was a lot of rumblings, early on about Bernie Sanders. My guess there is that that's not going to happen. It would appease the progressive side of the Democratic Party, but keep in mind that he's a sitting senator, and if he were to take a cabinet position, one, he might have trouble in the confirmation process, and two, Vermont, the state that he represents, has a Republican governor, and the legislature is that way as well, and so the state gets to appoint his replacement. So the Democrats are unlikely to do that. Of this list here, I think the two more likely folks to get it would either be Representative Levin from Michigan, who has a strong safety and health background, particularly, or Marty Walsh, who's the mayor of Boston. And I think his appeal to President-elect Biden is mostly in the organized labor context. He has a lot of NLRB experience, not so much on the safety and health side. But I think those are probably the two front runners to look at. Julie Su is interesting. She was a secretary for Cal OSHA's department there, so she has a lot of OSHA experience. So that would be interesting to see there. I was hoping to have a pick by this presentation today, so we could be able to provide a little more information to you. But I checked this morning, and I think defense got filled yesterday, or at least nominated, but nothing on labor. So stay tuned there. So in terms of names for the pick to head OSHA, OSHA's head is what they call an Assistant Secretary of Labor for OSHA. It is also a Senate confirmed position. And you'll see that the two names that I've seen, at least, that are kind of floating to the top are Jim Frederick or Chris Kane, both of whom come from union backgrounds. So, expect a lot of enforcement side emphasis from either of them. If they get the nomination. And frankly, if it's somebody else, which it very well could be, it's going to be somebody who has more of an emphasis on enforcement, which I'll talk about next. So again, what are we going to expect with the new OSHA, regardless of who is put? And keep in mind, we haven't had an Assistant Secretary of Labor since the Obama administration. Trump never had an OSHA head. One was nominated, but he never got even to a vote on the Senate. So OSHA was pretty much on cruise control for the last 4 years and didn't have that kind of direction coming from the top. And so they will have it now. And what that's going to mean is increased enforcement. President-elect Biden on the campaign trail made comments about wanting to double the number of OSHA compliance officers. Now, a lot of that's going to depend on what happens in January in the Georgia runoffs. who controls the Senate, but that's in large part going to dictate how far the parties can get in terms of a budget, which would include a budget for OSHA. So those kind of budgetary issues pending, we're going to see a lot more OSHA compliance officers out there. I don't know if it'll reach the doubling amount that Joe Biden wants, but it's certainly going to increase. Next slide, please. Couple of local changes here that I'll just talk to real quick. We have new area directors both in Denver and in Inglewood, and this has nothing to do with the election or the Biden administration. The area directors are career people; they don't come and go with the administrations. There have been just coincidentally 2 early retirements here in Denver. Herb Gibson retired. His slot was filled by Amanda Cooper. She comes to us from an area office back east, a lot of experience. I've dealt with her. She's very pleasant, very, very reasonable to deal with. And in Inglewood, Dave Nelson retired rather suddenly a few weeks ago. And I say suddenly, meaning he didn't tell me, and he certainly doesn't have any obligation to do that. And so Chad Vivian took over for him. Chad's been with that office a long time, both as a compliance officer and an assistant area director. So good to have Chad on board there. So that's who you'll be dealing with in your informals at that high level. Okay, looks like, and I apologize, it looks like we missed some slides here. Can you go back 2 slides, please, Alyssa? I want to talk about a few more changes under the Biden administration. I apologize, I had more after this, but I'll just talk about them. In addition to having increased enforcement, one of the things that you're going to see from the Biden administration, I think, is what's called a temporary emergency standard or emergency temporary standard, ETS, dealing with COVID. As Dana mentioned, there's some standards that OSHA can enforce under, some of the respiratory 134 standards. The citations that we're seeing are largely general duty clause, which, as everybody knows, apply in the absence of a particular regulation or standard. But because of that absence of standard, and this is something that OSHA has been roundly criticized for in the past 9 months, is not coming up with a standard to deal with COVID-19. The normal rulemaking process takes years. So, and obviously we don't have years with COVID to get to these emergency temporary standards. So there is a provision in the law that OSHA can, if it's necessary to protect people against a new and significant threat that otherwise can't be addressed through normal rulemaking, OSHA does have the power to implement an emergency temporary standard. And they've been criticized, like I said, for not doing it. So in the new OSHA, I expect very early on that they'll propose something. Now, it is subject to judicial challenge, so we're going to have a lot of issues there as to what they come up with, what it looks like, and what kind of legal challenges along the lines of infeasibility, impracticality. It's going to be too burdensome from a regulatory point of view. Those are going to be some of the challenges to it, but it will be out there and it will be enforceable. So I think, and Dana mentioned this earlier, there are some states that have enacted their own emergency temporary standards. California, Oregon, Michigan, I believe Virginia has. Again, these are all state planned states that run their own OSHA programs. And I think what Fed OSHA might do is look to the biggest of those, and that's California. And Dana touched on this in their emergency standards. They're requiring a lot of pretty onerous things. California already requires what's called an injury and illness prevention program, or I2P2. Now, all employers have to have those in California, and now they're required to add COVID programs to that. One of the things that I think is really interesting about the California standard is they're requiring employers to track their COVID cases and do that contact tracing. That's a best practice anyway, but now it's a regulatory requirement, and a lot of records have to be kept. And another one that they're having is there's mandatory exclusion of workers from the workplace when they've been in contact with somebody who's tested positive for COVID. So you have one workplace exposure, that could set out your whole workforce for 14 days. So those are the kind of things that we're seeing from California. Whether or not they make their way into a Fed OSHA standard, I don't know. In terms of long-term goals for the administration for OSHA under a Biden administration, I think you're going to be looking at a lot more rulemaking. In the past 4 years, and this is COVID and non-COVID, we haven't seen any real substantive rules come out of OSHA. I think you're going to see them pick up some more of that. I think we probably are going to see a more long-term, if not COVID-specific type of standard, then at least a more general infectious disease type of standard, which has been missing from OSHA standards for a long time. There are certainly ones that touch on it, but they're more specific. So certainly there's going to be more rulemaking. A couple of other things that we've been so consumed with COVID that a couple of other OSHA issues that we typically talk about that have kind of gone dormant over the last 4 years, I think might resurrect themselves, and that's the retaliation and the electronic reporting. Electronic reporting was a big controversy when it came out a few years ago. That's going to be ramped up. That's going to be, those electronic annual reports are probably going to end up being publicly available under a new OSHA, and I think we have to prepare ourselves for those fights. And then the anti-retaliation. So you'll recall if you've been to these before that in years past we've talked about, and Dana spoke about what's happening on the state level, which is actually has a lot more teeth to it than what OSHA does. But historically, OSHA only had what's called Section 11C of the Act to deal with retaliation. Well, a few years ago they promulgated a regulation that basically says you can't discriminate against people for reporting workplace injuries and illnesses. And there were some challenges to that it was duplicative of 11C, but they got around those largely. So that is still in effect, that standard. And what it basically means is if OSHA deems that you've retaliated against somebody for reporting an injury and illness, they'll actually issue you an OSHA citation. So I've never had that happen yet because OSHA under the Trump administration simply has chosen not to enforce it. But I think because it's on the books, it's nothing new that the new OSHA has to come up with. I think you're going to start seeing this being enforced. And what I really fear is that it's going to start being enforced in the context of COVID. So a hypothetical, an employee comes to you and says, I have COVID. I think I got it here, and is subsequently either disciplined or terminated or somehow suffers an adverse employment action. That person could go to OSHA and say, look, I reported this workplace injury. They didn't record it. Then they started harassing me, how the drill goes after that. Now, fortunately, it's not, that standard does not cover general complaints of, I think there's excess exposure here. It actually has to be tied to reporting an injury or illness, but the potential is there now for OSHA, I think, to be looking at that a lot more closely. So employers are going to find themselves in the position of having to defend an OSHA citation that really looks more like a retaliation cause of action, where you have the burden shifting of the employee or OSHA in this case has to put forth its prima facie case of retaliation. The employer comes back with its legitimate, non-discriminatory, non-retaliatory reason, and it looks like an employment case. And the review commission judges who hear OSHA cases aren't used to that sort of type of case, and nor are OSHA compliance officers used to investigating those types of cases. So that's another area that I think is going to be really, really interesting under the new administration. So there's a lot of stay tuned with this. We'll be putting out updates as we get these new developments coming in, but OSHA is going to look a lot different in the next 4 years. It's going to go back to looking a lot more like it did under the Obama administration. Case in point, the Assistant Secretary of Labor for Obama during his tenure is a gentleman named David Michaels, Dr. Michaels. And he was very pro-enforcement since since the Trump administration took over, he's been out there in the public domain being very critical of OSHA's lack of enforcement. Well, he was just named just last week, I believe, to President-elect Biden's COVID-19 task force. So to the extent that OSHA is going to be doing anything with COVID-19, I think you're going to have Dr. Michael's hands on that. And so that's going to be towards regulation and enforcement. Would someone be able to pursue legal action against that business, school, district, or government body? That's a great question. It's a little bit out of our wheelhouse because we do regulatory law. But the answer to that is yes. Now, governments have what we call sovereign immunity. So they can't be sued in most cases. If you're a business and it's one of your employees, workers' comp could apply to prohibit any other civil litigation. But yeah, if you're a member of the public and you go in and you can prove, one, that you contracted COVID-19 at that facility, which is going to be hard to do for the reasons we discussed earlier, and that facility was negligent in its COVID-19 protocols, yeah, theoretically that could happen. And I think you might be seeing that with supermarkets down the road. But again, I'm not a civil litigator handling those types of negligence cases, but it's possible. But I think the problem people are going to have, again, is in the proof. If I'm representing one of those businesses, I say, how do you prove that this person contracted it at my client's store? And then we'll get into all the same issues. How many other gatherings did you go to? When did you contract it? Do you even know when? That sort of thing. So yes, it's possible. I think it's going to be difficult. How do you determine if a how do you determine a COVID work-related death? Again, that's going to be really difficult. And another kind of twist on this with COVID is a lot of people who die, quote unquote, of COVID, it's COVID that complicates another pre-existing condition or comorbidity. So if somebody has a heart problem, for example, and they get COVID, they might otherwise have survived it, but COVID exacerbates their heart condition. Is COVID the cause of it? Well, for OSHA reporting and record keeping purposes, it's really more of a, did it cause or significantly contribute to it? So in those types of cases, yes, it would be considered work related. But again, you get back to the work relatedness questions about, did it happen at the work? With regards to fit testing and N95 respirators, does an N95 require extensive fit tests like a cartridge respirator, or does a simple on and off explanation and general use criteria suffice? That's a real technical question. N95s are subject to the fit testing and med-eval when you're requiring them for respiratory protection. But I don't know the technical specifics of what they go through for that fit test. But that raises an interesting issue that I've seen come up actually in an enforcement action. What happens if you as an employer provide your employees N95s for COVID protection as masks? Now, as Dana mentioned earlier, masks that are used for COVID respiratory protection, not respiratory protection, for COVID purposes are not respiratory protection under 134. They're not PPE. You don't have to have your employees fit tested or have a medical evaluation done or anything like that. Any indication if the COVID public health emergency will continue into 2021? I don't know. I think that question reflects a lot of fatigue that we all have. I think, a lot of it depends on a vaccine. And the vaccine raises certain interesting issues. We're doing a lot of discussion amongst the attorneys in our group internally about whether or not employers should or can mandate vaccine uses, things along those lines. But I thought of an interesting issue. In OSHA's enforcement of any COVID-19 regulations, could OSHA actually require employers to mandate that their employers get vaccinated. I think that would be quite a stretch. I think there'd be a lot of religious type of objections to that, health type of objections to that. But the vaccine is also going to be, and I should have spoken more on it in the what to expect from OSHA portion, but I think the vaccine issue could play out with OSHA as well. For general duty clause may come up down the road with vaccines if it becomes pretty common for employers to require them and certain companies aren't. You may be looking at those type of issues there. So let's see, we have a couple more minutes. What is the best way to send notices to employees on the state? I assume that refers to the state anti-retaliation law.
Well, I would say for that, you could certainly just print a copy of it and physically hand a copy to your employees. Obviously, some of us aren't meeting with our employees face-to-face regularly. Another way to do that would be to send an email, or I know in the future they are going to also allow people to include it in their handbook. And as long as those are readily available and all the employees know where to find those, that is another way to distribute the information.
Okay. And one final question. What are the penalties for failure to record or report? Very small. They're usually considered, other than serious violations, maximum penalty of $13,000, but they don't even get that high. I think in cases where OSHA feels that an employer is really underreporting a vast number of cases, OSHA could go to a case-by-case penalty there. But typically, at least as of now, under the current enforcement regime, they're not very onerous. We will be making the slides available, and please, anyone call or email with follow-up questions anytime. And it just underscores the fact that I really cannot wait until next year when we all get to do this in person and sit around a table and have a meal and discuss these things as people should. So we're at our time now. Again, thank you very much for your patience with us and for your attendance, and we really appreciate you.